I request Shri V.P. Raja, Chairman of the Maharashtra Electricity Regulatory Commission, to kindly take over and chair this session. Thank you.
Thank you very much. Thank you, Mr. Naveen Kapoor. Mr. Naveen Kapoor brought out quite succinctly the broad aspects of what is often called the franchisee model. When we talk of public-private partnership, these days, by and large, people assume that the franchisee model is by and large the model which seems to be succeeding, particularly after the B1D success. But we must realize that there are various ways in which investors can get into the distribution business. That was mentioned in passing by Mr. Naveen Kapoor. The first thing to realize is under Section 14 of the Electricity Act 2003, anybody can apply at any time before the regulator for a distribution license. The only condition is there is that sixth proviso to Section 14, and the regulator cannot deny a license only on the ground that there is already a licensee. Which means there is a clear-cut provision for a second, third, or multiple licenses in the same geographical area. So there is a route available by which if any investor wants to get into the distribution business, the law is available even today. He needs to apply after studying Section 14 and in particular the sixth proviso to Section 14, which puts some conditions regarding creditworthiness, capital adequacy, and code of conduct. Now, creditworthiness and capital adequacy are well known, and the code of conduct is under various laws of the land which are listed in rules made by the Government of India. The concerned person should not have been prosecuted, starting with the Income Tax Act and various other things. The various laws are listed out in rules made by the Government of India, and he should not, which means it is basically a clearance of the past of the person who is coming in. So, subject to creditworthiness, capital adequacy, and code of conduct, anybody can apply to the regulator for a distribution license. There is one other condition which is in the rule book as of now, and I will slightly correct what Mr. Naveen Kapoor said, and that is the so-called minimum area requirement. A person can apply for a distribution license for a minimum area which should at least be a revenue district or a municipal council area or a municipal corporation area. That is, you cannot apply for a license smaller than this minimum area of either a revenue district or a municipal council corporation area. And as I said, then it's for the regulator to take a view. But he has to take a view for reasons to be given in writing. And if you are not satisfied with the regulator's view, you can go to the Appellate Tribunal for Electricity and then to the Supreme Court. So which means at the whims and fancy of the regulator can't reject such an application. And on any case, he cannot reject it on the ground that there is already another licensee there. However, this is what is called the system of parallel licenses, which is provided for in the Electricity Act. However, the person proposing to come in this fashion should lay his own network. So he must also give a rollout plan of how he proposes to lay his network in at least that minimum area of a revenue district or a corporation. The reason I'm mentioning this is, even today, anybody can come in for a license in an area. We in Mumbai had actually invited expression of interest. Many people applied. But perhaps there was a misunderstanding, not a misunderstanding, a feeling that the existing licensee will be replaced. The real condition that is required is he has to put his own network. Obviously, he can't put it up overnight. So there must be a rollout plan. Until the complete rollout is reached, which could take 5 years, 10 years, depending on the area which you choose. If you choose a virgin area, it can perhaps be done in as little as a year. If it's an area which is already built up, it will take a longer time because you'll require various municipal permissions, diggings, etc. In a city like Mumbai, you can't even dig for 6 months in a year during the monsoon months. While if it's a completely virgin area, you can perhaps roll out your network in a year's time. So that is one thing. A second point I want to mention is, very, very quietly, a large number of licensees have already come into existence, besides the people whom you know as licensees. And these are the so-called special economic zones. Under the SEZ Act, the government has already amended the Electricity Act, where all SEZs have been legislated to become deemed distribution licensees. And most of the SEZs don't know what to do with it. So if there are people who have experience in distribution business or who want to get into the distribution business, join hands with SEZs. In Maharashtra itself, there are 58 new licensees which are come into effect over and above the old licenses which we had, because there are 58 notified special economic zones. Now, otherwise, I want to disabuse people of the thing that bringing in a new private sector party necessarily means privatization. A private sector party can be brought in without displacing the existing person to give him competition. Because the real intention of the Electricity Act is to bring about competition. Privatization can be one method of doing it, but there is no necessity to displace an existing licensee to bring in a new licensee.